Hello and welcome everyone to this Fieldfisher webinar on the EU AI Act. My name is Olivier Proust. I'm a partner in the Tech and Data Department in Brussels. I'm joined today by Leonie Power, partner in the Tech and Data team in the London office, and Ines Benazouz, associate in the Tech and Data team in the Brussels office. This webinar will be recorded and will be posted at a later stage on our YouTube channel, so you can go back and view it once again if you wish to. If you wish to ask any questions, please insert your questions in the Q&A box and it will try to answer as many of them as possible at the end of our presentation. So today's topic, we would like to discuss some of the key legal developments concerning the EU AI Act and focus in particular on some guidelines that were adopted and released a couple of weeks ago by the European Commission, focusing on the definition of AI systems and on the AI prohibited practices. The context in which these guidelines were prepared, well, essentially the European Commission worked with various stakeholders such as companies, civil society, academia, and the guidelines do state that they are non-binding, but nonetheless very useful, and they do provide some practical explanation on how to interpret some of the key provisions of the AI Act. The European Commission also mentions that these guidelines will be reviewed regularly in light of experience that is gained over the months and years to come, and also taking into account the technical and market developments in a particularly active field of artificial intelligence. So in today's presentation, we will focus on three key topics, which are the three main provisions that have come into full application, namely, what is an AI system? And then we'll talk about AI literacy, and we'll also focus on some of the prohibited practices under Article 5 of the AI Act. Before that, just a reminder of the timeline. For those who know, the provisions of the AI Act come into full application gradually. So there's a calendar that is set out at the end of the AI Act. And what we are focusing on today is what appears in red on this slide, namely the provisions that are now in full application since the 2nd of February 2025. That is the general provisions, which includes the definitions and the scope of the AI Act, the provisions on AI literacy, and the provisions on prohibited practices. As you can see, the other provisions of the AI Act will come at a later stage and different dates throughout this year and up until 2027. Now with that, I pass it to Leonie to talk to us about the definition of an AI system.
Thanks very much, Olivier. Next slide, please. Okay, so on this slide, you'll see the 7 main elements that have been identified by the guidelines issued by the European Commission in relation to the definition of AI system. So these 7 elements are the elements that are contained within the definition found in the EU AI Act. An AI system is defined in the Act as a machine-based system designed to operate with varying levels of autonomy, and that may exhibit adaptiveness after deployment, and that for explicit or implicit objectives infers from the input it receives how to generate outputs such as predictions, content, recommendations, or decisions that can influence physical or virtual environments. So on the slide, you see 7 key elements of that definition. Now, this definition aligns with the OECD definition. It is different from the definition that was originally proposed by the Commission in April 2021. That original definition was criticised as not providing clear enough criteria in order to distinguish AI systems from simpler software systems. The view that was that it effectively was too broad, and it could potentially include traditional rule-based systems that don't exhibit learning capabilities that are associated with AI. So it's felt that the key elements of this definition that made its way into the EU AI Act will help to distinguish an AI system from those more simple software systems. And a key ingredient of that definition is the ability of the system to infer. And this capacity to infer essentially goes beyond basic data processing. So as we know, the definition came into force itself on the 2nd of February, and on the 6th of February, the European Commission published non-binding guidelines on the definition of AI systems. These guidelines were adopted in parallel to the guidelines on prohibited AI systems on the basis that the definition is essentially definitive to understanding the scope of the AI Act, including in relation to prohibited AI systems. What's made clear in the guidelines is that each system must be assessed based on its specific characteristics. And what the guidelines make clear is that the definition essentially adopts a life cycle based perspective that encompasses two main phases. The first phase being the building or pre-deployment phase, and the second phase being the use or post-deployment phase. And the guidelines make clear that the elements set out in the definition are not required to be present continuously through both phases of the life cycle. And that approach essentially, reflects AI systems complexity and diversity. So there are some of the key takeaways of the EU European Commission guidelines in that respect. Next slide, please, Olivier. Okay, so we're going to look in turn at each of the ingredients of an AI system. The first is that it's a machine-based system. Obviously, we can see from this slide that it can be part of a product or it can be an independent product. It can be embedded, so physically integrated into the product, or non-embedded, so it'll serve the function of the product but without necessarily being integrated into it. But what's clear is that it's running on machines. So it's relying on hardware and software for functions like, training and data processing and automation. And this ensures that they are computationally driven. So we'll exclude things like anything that involves a human decision-making process. An obvious exclusion there, I just included it on the slide by way of illustration, is a board game, for example. But what's made clear in the Commission guidelines is that the term machine-based covers a wide variety of computational systems, and it refers in particular to the most advanced emerging quantum computing systems, which represent a significant departure from traditional computing-based systems, but they constitute machine-based systems. So, the term machine-based would also cover those systems. Next slide, please, Olivier. So we look at the next ingredient, which is that the system is designed to operate with varying levels of autonomy. And what we're talking about here is the degree to which a system can learn or act without human involvement. And of course, there will be human involvement at some point. So what we're really talking about is a delegation of autonomy to certain AI systems that can generate outputs without those outputs being explicitly described in the AI system's objective and without specific instructions from a human. So AI systems will include things like, a robot vacuum cleaner or a self-driving car or automatic stock trading software, but will exclude the simpler systems that require constant human input for every decision, like, for example, a traditional calculator. That's deemed to fall outside the definition of an AI system because it operates based on fixed and predetermined mechanical processes without any form of learning or adaptation or decision-making capabilities. And if, for example, we look at, let's say, a remote controlled drone, well, the question arises, well, is the human flying it or does it fly autonomously? And ultimately, the human is flying it because it's operating based on direct human input because the user is controlling the drone's movement via remote control. That said, a drone can be equipped with certain AI capabilities that will enhance their functionality, like some kind of object avoidance capability, for example. Okay, next slide, please, Olivier. So we're working our way through the different ingredients of the definition. And so the next ingredient is that the system may exhibit adaptiveness. And what we mean here is that the system will modify its behavior through some kind of direct interaction with the inputs into that AI system and or the data that's fed into the system before or after deployment. And what's interesting for us to know is, of course, that AI systems can develop over time. Now, that can be a good thing or it can be a bad thing, but it is something that you should be considering within your contracts. The key differentiator here is that, a traditional software system, you'll want it to conform to a particular specification. You may need to be more creative in your drafting in AI contracts to consider the parameters of the outputs that you might want from a particular AI system. And so that's just something to bear in mind in terms of that particular ingredient. But examples of adaptiveness, for example, include a speech recognition system that adapts to an individual's voice. Now, a system does not have to be adaptive to be an AI system. And you can see that from the language of the definition. It talks about the fact that it may exhibit adaptiveness. For example, expert knowledge systems do not display self-learning capabilities, and that's because they are specifically designed to operate on a fixed set of rules and knowledge that is provided by human experts. Now, some of the key takeaways from the European Commission guidelines are that, the concept of autonomy and adaptiveness are related concepts, but they are distinct. So adaptiveness refers to self-learning capabilities that will allow the behavior of the system to change while it's in use. And the new behavior of the adapted system may produce different results from the previous system for the same inputs. Next slide, please, Olivier. Okay, so again, working through the ingredients. So we're talking about the fact that the AI system is a machine-based system that is capable of inference for explicit or implicit objectives. So looking at the objectives, where we talk about explicit objectives, what we're talking about there is explicit and human defined objectives. So the developer is encoding the objective directly into the system, be that some sort of simple classification objective or some sort of objective within a game playing system or within a reinforcement learning system. Now, in some cases, the objectives can be implicit. So you will have a particular rule and the objective is implicit in the rule. So the rule will dictate the action to be taken by the AI system. For example, a driving system might have a rule, if the traffic light is red, then stop. However, the underlying objective is, in that case, compliance with the law or avoiding accidents. And that underlying objective is not explicit per se. Now, in some cases, the objective can be implicit within the training data. So there, the ultimate objective is not explicitly programmed, but it's incorporated through the training data and through the system architecture that learns to emulate those data. So an example might be rewarding large language models for generating a plausible response. Now the objectives don't have to always be fully known in advance. So some examples would include recommender systems that use reinforcement learning to gradually narrow down a model of individual user preferences. And the other thing is that user prompts can supplement objectives during the deployment phase. So if you look at, for example, some sort of a GPS navigation system within your car, then a specific destination is supplied by the user in order to get to that destination to supplement the objectives. So, you have AI systems also can operate to one or more types of objectives. Now, some of the key takeaways from the guidelines from the Commission are, that explicit objectives refer to clearly stated goals that are directly encoded by the developer into the system, and implicit objectives refer to goals that are not explicitly stated, but may be deduced from the behavior or underlying assumptions of the system. Next slide, please, Olivier. So the next ingredient is the inference ingredient. So the system infers how to generate outputs. So the concept of inference refers to learning and reasoning and modeling in order to produce a particular output. Now that can be achieved by inferring certain patterns from data, for example, or it can be achieved by deriving new information based on logical rules. So, you can have also logic-based inference, where within the system information is represented using logical statements such as facts and rules. So there might be a rule, all humans are mortal and Socrates is a human. And there'll be inference rules built into the system such that, if A implies B and A is true, then B must also be true. And that's used then to derive new conclusions. So the system would deduce based on the knowledge that's built into the system. Well, it will deduce all humans are mortal. Socrates is a human. So it deduces that Socrates is mortal. And that's an example of a logic-based inference. And again, a key takeaway from the European Commission guidelines is that these techniques may be used to, that may be used to enable inference, include machine learning approaches that learn from data how to achieve certain objectives and logic, and can also include knowledge-based approaches, as in the example that I've just given. Next slide, please, Olivier. And here we see the ingredient, and this is a few slides based on the same ingredient, which is infers from inputs how to generate outputs. And we're just looking at the breakdown of the different parts of that particular ingredient. But looking at the outputs now, what we're talking about here is the fact that outputs will generally belong to broad categories of recommendations, predictions, and decisions. So, for example, a driver assist system, bit of a tongue twister there, might predict that a pixel region in its camera is a pedestrian, and it might recommend braking, or it might decide to apply the brake. And so you can see from that example that the most autonomous type of output is the decision. So the system is deciding to brake. The system is directly affecting its environment, or it's directing another entity to do so. And you can see from that example that a prediction is the least autonomous. So it predicts that the pixel region in its camera is a pedestrian, but it leaves the decision making up to the relevant human in the circumstances. And then if we look at content, we see that within the definition of AI system, content is a category of its own. Now, you could potentially argue that content, for example, in the case of text, is a sequence of decisions to output particular words one after another. So you could see it as a series of decisions. But content generation systems have become such an important class of AI system that they're included as their own output category within the definition of AI system. Next slide, please, Olivier. Okay, and still looking at this ingredient of inferring from the input it receives how to generate certain outputs. This time we're looking at the input. We can have input either during development or after the deployment of the AI system. Now, the input can take the form of knowledge or rules and code humans put into the system during the development, or it can include data. So both humans and machines can provide input. And during the development phase, input is leveraged to build the AI system. So the machine learning will help the model learn from training data and or human input. But input is also used by the system once the system is in operation. For example, it can take the form of some kind of user prompt or search query. Next slide, please, Olivier. Okay, and The final ingredient of the definition is the fact that the AI system can influence physical or virtual environments. Now, when we talk about an environment in relation to an AI system, what we're talking about is an observable or partially observable space that's perceived using data and sensor inputs and influenced through actions. Now, the environments that are influenced by AI systems can be physical or they can be virtual, and they can include environments that describe aspects of human activity like biological signals or human behavior. Again, the guidelines from the EU Commission comment on this particular element of the definition, and they make the point that interaction with the environment should be understood as emphasizing the fact that AI systems are not passive. They actively impact the environments in which the AI systems are being deployed. And it also calls out, those guidelines also call out that reference to physical or virtual environments indicates that the influence of an AI system might be to both, tangible physical objects, as in the case of a robot arm, or to virtual environments like digital spaces, data flows, software ecosystems, etc. Okay, so that has taken us through the different ingredients of an AI system and some of the elements of the guidelines that were provided by the European Commission. I'll now hand over to Olivier, who'll comment on AI literacy.
Thank you, Leonie. And indeed, one of the other key provisions of the AI Act, which is now in full application, is the Article 4 on AI literacy. Now, unlike what we've heard about AI systems, where the European Commission has issued some guidelines, and what you will hear in a minute on the AI prohibited practices, there is currently no regulatory guidance, at least not from the European Commission, on AI literacy, although they have announced that they will release some guidelines at some point. So what do we know about the AI literacy requirement? Well, I'll start with what we don't know or what we don't have, which is some practical elements on how to build this within a company's governance framework, how to implement, who is going to be in charge of implementing AI literacy within the company. So we don't have a lot of information on the practical elements or the practicalities of AI literacy. So what do we know? Well, what does Article 4 say? It says a few interesting things. First of all, it says that it applies to all providers and deployers of AI systems. So there is an element of generality in that the AI literacy requirement is not bespoke to certain actors within the AI ecosystem or to limited to certain entities, but rather it applies to all providers and deployers. The second thing that the Article 4 mentions is that organizations need to train all of their staff, or in a more broad sense, the persons that are dealing with AI. So here again, the requirement to train and to make individuals AI literate is not reserved to specific functions or individuals within the organization, but has the potentially can apply to everyone, at least everyone who deals or who has access to AI systems. Probably the most interesting element of the definition is on what needs to be provided, what actually defines the AI literacy. It's the fact of providing skills, knowledge, and understanding. So that is at the same time useful and a little bit vague. We will have to wait to see the regulatory guidance to understand exactly what is meant by skills, knowledge, and understanding. But we do understand that the intention here of the Commission is to indicate the necessity to upskill people on AI as a technology, but also on the impact of AI on individuals and within the organization. And then finally, it says that AI literacy programs should be tailored to people's knowledge, experience, education, and the context in which the AI system is going to be deployed. And here, this is, again, quite interesting, because what this indicates is that you're not necessarily going to provide the same type of training on AI to all of the employees within your organizations. In fact, you're going to have to tailor it to their specific functions, to the manner in which they are either using or developing or accessing AI systems, and based on their knowledge and their experience, and also the context, which is really important here. So as I mentioned, we don't yet have any guidelines from the European Commission. However, some data protection authorities are beginning to release some guidelines. This is taken from the guidelines that were released a few days ago by the Dutch Data Protection Authority. And here, once again, the Dutch DPA does not go into a lot of details on the practicalities, but it does give some interesting indications on what is the purpose of AI literacy. So things such as protecting fundamental rights, obviously boosting trust in AI, which is an important topic for any organization. Also, it is aimed at helping the key stakeholders to make their decisions around AI, how it's going to be used and deployed, and so on and so forth. So there are different elements that we can extract already from this regulatory guidance to help organizations to start building and implementing their AI literacy programs. But I will now pass it back to Leonie to explain to you in more detail what should companies be doing.
Thanks very much, Olivier. We just wanted to give you a little flavor of some of the things that we've been doing for clients, or some of the things we can potentially do for clients to support them in relation to their AI literacy compliance programs. One option is, and this is something we've been doing, is looking at existing AI literacy plans. So what the existing training and policies say, and as part of that, identifying key AI governance stakeholders within the particular company. And I guess that feeds in also to the broader governance piece, because key to any kind of governance program is identifying appropriate stakeholders and potentially actually leveraging existing stakeholders who are involved in other governance programs, perhaps from a privacy perspective or a broader risk perspective. But identifying those stakeholders, identifying what's already there in terms of training and policies, and providing guidance notes to understand where the gaps might exist, so that there's a clearer path to compliance. As I've mentioned, I think AI literacy is a fundamental segue into a broader governance piece, and so it will be part of any kind of monitoring and feedback mechanism, is to understand how that literacy program is working, and to ensure also that the literacy program is properly documented from an accountability perspective. The other option is, introductory or bespoke training, introductory to, just introduce the organization to the taxonomy of AI, make sure everyone's using the same taxonomy, the same terms, and also then to work out from those introductory training sessions where bespoke training should be provided for staff. And whether that's in the HR context because of a new recruitment tool, or some other AI system is being deployed within the organization, and kind of working out who's going to be using that and who needs training on that, and formulating more bespoke sessions in that regard. Just wanted to also give you a flavor of, if you wouldn't mind moving to the next slide, please, Olivier, of where AI literacy fits into the governance piece, and also how perhaps some of the things that you've been already doing from a governance perspective feeds into the overall AI governance piece. And this is the concept of the AI onion, which is, looks at governance in a broad context. So one of the things that we've been seeing is an organization saying, well, where do we start from an AI governance perspective? And broadly speaking, we see there being, roughly 3 phases. One, to identify stakeholders and to set objectives. And I think setting objectives is around, having a clear charter or principles around responsible or ethical AI. And then basically the next two phases are about operationalizing those principles or that charter. And often the principles and charter will be in line with values or codes of practice within the organization. So the second phase would be about, risk management, assessing what risk looks like. And there'll be a whole series potentially of risk assessments that are coming into play there. So you'll see on the right-hand side a reference to certain assessments that are triggered by regulatory requirements under the EU AI Act, potentially depending on the AI system in question. So you'll see then within the broader governance piece, there's the legal and regulatory risk piece, because of course legal and regulatory risk is an ingredient, but it is not the only risk that arises. There are a whole myriad of risks to individuals and groups and companies, and indeed to the ecosystem and the environment. And so the AI governance piece more broadly looks at risk management across the board. Obviously, there'll be a legal and regulatory risk management piece to that, which will look specifically at the EU AI Act, for example, and where you might come within the requirements of that. So, what's your role? Is it as a deployer, as a provider? Are you deploying or providing an AI system? Are you a provider of a general purpose AI model? Does that AI model have systemic risk? And that's, will determine basically the risk levels and what steps you need to take to mitigate that risk. So, and obviously there'll be other regulations that will come into play there. You might have product liability legislation, etc. But that's the purple piece of the onion, looking at that specific legal and regulatory risk. And then within that, of course, you've got GDPR compliance, and we'll all, many organizations will already have lots of templates and lots of procedures around dealing, for example, with data protection impact assessments. So it's really about looking at those and addressing AI specific challenges. So you might, for example, in the context of a DPIA, want to think about, well, do I need to actually collect some sensitive data in order to offset the risk of bias? Is there a trade-off there? How do I document that? And also updating various privacy artifacts like privacy notices, etc. But then, of course, as well as addressing the AI challenges within your existing privacy framework, expanding out your assessment framework to make sure it covers those assessments that are needed under the EU AI Act. So if we go back out to the purple piece, is there a fundamental rights impact assessment needed? Potentially, if you're a deployer in certain circumstances, the answer is yes. In any event, it's likely that you should be doing an AI Act risk assessment for to work out whether you come within, a high risk system. That won't always be relevant, and it might be that you have a cutoff point where within your organization you say certain AI systems that are meeting certain criteria are low risk and they won't get escalated for further review. But having some templates around AI Act assessment, and I think Olivia is going to talk a bit more about that, will be important. And then it may be that you've got to do some kind of conformity assessment, and then you need to think about maybe transparency and explainability notices beyond the privacy ones, thinking about vendor due diligence and also what might go into your contract playbooks and templates. So I just really wanted to give a whistle-stop tour of that so that we understand the context in which we're dealing with these EU AI Act obligations, and pointing out that there is that broader AI governance piece, notwithstanding the specific requirements of the EU AI Act. And on that note, I'll hand back to Olivier to talk about prohibited practices.
Thank you very much, Leonie. And I'm going to hand it to Ines in a minute, who is going to walk us through some of the prohibited AI practices. But before I do so, I just wanted to give you some, three key takeaways from the European Commission's guidelines on those prohibited practices. First one, on the material scope. So the European Commission specifies that these provisions on prohibited practices apply to AI systems that are either placed on the market, put into service, or used in the EU. Now, for those of you who have already looked into more detail about what these different concepts what they mean, you will know that they apply mainly to the providers and deployers. So I think in this context, it's mainly providers and deployers of AI systems who are going to have to assess whether their AI systems are potentially, whether they fall under a prohibited practice. Second key takeaway, these prohibited practices should also be considered in relation to the high-risk AI systems under Article 6. Now, this is, I think, really interesting and particularly relevant in the context of a AI risk assessment. Why? Because you do have some some notions or concepts that appear both under Article 5 for prohibited practices and Article 6 for high-risk AI systems, but obviously the context in which they are used is what is going to determine whether they are prohibited or simply high risk. And to give an example, we have emotion recognition systems or scoring mechanisms or biometric identification. And depending on how you are developing or deploying these types of AI systems, they may either be prohibited or high risk. The third and final key takeaway is the importance of also taking into consideration the interplay between these provisions of the AI Act and other provisions, other laws, particularly at a national level, so EU member state laws that can apply and that can also have some, well, there are specific provisions on AI or on the use of AI. And in this context, the European Commission says you have to look at those other laws. For example, data protection laws. We know that the Article 22 on automated processing activities is a form of AI provision, but also employment laws, discrimination laws, or consumer laws. So the EU Commission does warn companies that it's important to have a broader perspective on AI practices, and it's not because you exclude a prohibited practice under the AI Act that you're clear from having to comply with certain other bespoke or national specific provisions that may also apply. So with that, I will pass it over to Ines, who is going to present these prohibited practices to you.
Thank you, Olivier. So in the following slide, we will walk you through 6 of the 8 prohibited practices listed under Article 5 of the AI Act, excluding real-time remote biometric identification and predictive policing, which mainly concern law enforcement activities. So moving on to the next slide. So the first prohibition concerns exploitative AI systems. So as you know, the AI Act prohibits AI systems that exploit any vulnerabilities of individuals due to their age, disability, or specific social or economic situation in a way that distorts their behavior and causes them significant harm. So firstly, what does vulnerability mean, right? The regulation does not define this term, but the European Commission guidelines refer to various susceptibilities such as cognitive, emotional, or physical factors that affect individuals' ability to make informed decisions or which influence their behavior. So such vulnerabilities are linked to age, for example, minors below the age of 18, disabilities, including physical, mental, or sensory impairments. Also, socioeconomic situations such as individuals living in extreme poverty or from ethnic or religious minorities. So for example, an AI system that is used to target older people with deceptive personalized offers or scams in order to influence them into making decisions that they would not have taken otherwise is prohibited under Article 5. So second, the exploitation of such vulnerabilities must be intended to or result in influencing their behavior in a way that is likely to cause them harm. So in this regard, the exploitation must lead to significant consequences, and harm includes a range of negative effects such as physical, psychological, financial, or economic damage. So for instance, an AI system that uses emotion recognition to support mentally disabled persons in their daily life may also manipulate them into making harmful economic decisions. So ultimately, the goal of this prohibition is mainly to ensure that AI systems do not worsen social inequalities by exploiting these vulnerabilities. So moving on to the next slide, please. So the next prohibition concerns certain facial recognition AI systems. So more specifically, the prohibition concerns the development or use of AI systems that create or expand facial recognition databases through the untargeted scrapping of facial images from the internet or CCTV footage. So 3 conditions must be fulfilled. So first, the AI system allows for the creation or expansion of facial recognition databases. So the guidelines define facial recognition database as an organized collection of human faces from digital images or videos, which are compared against stored images to identify potential matches. So please note that the database does not need to be exclusively dedicated to facial recognition, but it is sufficient that it has the capability for such use. So this is a significant point to consider since it broadens the scope of the prohibition to include AI systems that could potentially be repurposed for such use. So secondly, the database must be populated through AI tools for untargeted scrapping, which involves automated tools like web crawlers or bots that extract data automatically from sources such as CCTV, websites, or social media. The notion of untargeted scrapping refers to the indiscriminate collection of data similar to a vacuum cleaner without targeting specific individuals or group. And lastly, the sources from which the facial images were collected are either from CCTV footage or from the internet. So this prohibition applies to facial images scrapped from CCTV footage captured by cameras in public places such as airports, streets, or parks, and from social media as well. Moving on to the next slides. So the third prohibited practice concerns certain biometric categorization AI systems, which classify individuals based on their biometric data to deduce or infer sensitive attributes such as race, political opinion, trade union membership, sexual life, or sexual orientation. So first, the AI system must use biometric data, such as facial images or fingerprints, in order to classify individuals. So this categorization typically involves determining whether the collected biometric data corresponds to a group with specific predefined characteristics. It is not focused on identifying or verifying the individual's identity, but rather on assigning them to a particular category. So it may use physical characteristics such as facial features, skin color to assign those individuals to specific categories, some of which may be sensitive or protected by union law, such as non-discrimination law, such as race. So second, the AI system is used to deduce or infer their race, political opinions, or other sensitive attributes. And for example, we can mention a biometric categorization system, which is capable of deducing an individual religious orientation from their tattoos, for example, that would fall under the prohibition. So I will now hand it over to Olivier for the next prohibited practices.
Thank you, Ines. And so the next prohibited practice that we are going to talk about are the manipulative AI systems. Now, these are defined as AI systems that use subliminal techniques or purposefully manipulative or deceptive techniques that impair informed decision making and may cause significant harm. So here we have, again, 3 possible categories of such manipulative systems. The subliminal techniques are those that are based on audio, image, or video stimuli that individuals cannot perceive because they are beyond the normal human perception. These are things that have existed already for some time, so this is nothing new, but obviously in this context, they are now prescribed under the AI Act. The second category are those that the purposefully manipulative techniques. Here we are talking about techniques whereby individuals are going to be influenced or pushed into a behavior or to make a decision that they normally would not make if they were not subject to such a manipulative technique. And so we're talking about techniques that bring individuals to a point that undermines their autonomy and the possibility for them to make a free choice. So such examples might be sensory manipulation, where an AI system deploys background or audio or images that lead to mood alterations. For example, by increasing the anxiety or the mental distress of an individual, and is going to influence that individual's behavior to the point that it can create a significant harm. The third type of technique are the deceptive techniques. Here we are talking mainly about techniques that subvert or impairs a person's autonomy. So, for example, presenting false or misleading information with the objective of deceiving the individual and influencing the individual's behavior in a manner that undermines his or her autonomy and free choices. So an example that we can think of would be an AI chatbot, for example, that impersonates a friend or a relative with a synthetic voice and tries to pretend that it is the person causing scams and significant harms. Or another example might be an AI system that learns to identify when it is under evaluation and it temporarily halts some undesired behavior and later on then resumes that behavior once the evaluation period is over. So we can see how through those examples there is an intention to be deceptive. The European Commission guidelines do mention that generative AI systems that incidentally present false or misleading information and things such as hallucinations would not be considered as deceptive practices or techniques and would not fall within the scope of this prohibited practice. And you do have some specific exceptions that are provided for that apply in the field of medical treatment and commercial practices that are legitimate and lawful. Then we also have the social scoring systems. Now, social scoring systems use AI to analyze a person's social behavior or personality or the individual's personality characteristics over a certain period of time with the intention of assigning a score to that individual, and that score can lead to unfair or harmful treatment. Here, the notion of evaluation, in fact, is similar to the concept of profiling that we are familiar with under the GDPR. This has to be done over a certain period of time. And the social behavior includes an individual's actions, behaviors, habits, or interactions within society, and usually covers behavior that relates to data points that are extracted from multiple sources, referring to that individual social and private life, for example. So there are various examples that we can provide, such as government-driven social control systems, such as a national system that scores citizens based on their financial habits or punctuality and social interactions. These types of social scoring systems are prohibited. At the same time, there are some exceptions. So lawful evaluation practices of individuals that are carried out for specific purposes and in accordance with union or national law are lawful and therefore will not be prohibited. So in the banking or financial services sector, scoring for creditworthiness purposes, for example, would fall within that exception. It's not considered as a social scoring, even though it's a type of scoring activity. And then lastly, we have the emotion recognition AI systems. Now, this is an important one because it has a potentially large scope of application. Essentially, we are talking here about systems that infer emotions from individuals, exclusively natural persons, and this has to be carried out in the workplace or education institutions in the context of education. Now, when we talk about emotions, we talk about things such as happiness, sadness, anger, surprise, or embarrassment. These are just examples. It does not apply to physical states. So assessing or inferring pain or fatigue, for example, do not fall within the scope of this prohibition, and therefore systems that detect pain or fatigue of professional pilots in planes or truck drivers, for example, to prevent accidents does not fall within the scope. Also, the mere detection of expressions or gestures or movements also will not be considered as emotion recognition unless they are used specifically to identify or infer an emotion. So observing that somebody is smiling, for example, is not an emotion recognition. Same thing, identifying whether somebody is sick is not emotion recognition. But if you are analyzing someone's expressions or gestures for the purpose of identifying or inferring specific emotions, then that will fall within the scope of the prohibition. So we see how context here is really important. And then one important element is that we are talking about AI systems that identify and infer emotions or intentions based on an individual's biometric data. So again, looking at some practical examples, an AI system that infers emotions only from a written text that reveals an individual's sentiments or feelings is unlikely to fall within the scope of this prohibition because the written text is not biometric data. On the other hand, if you're applying the same system on keystrokes or facial expressions or body postures and movements, then those constitute biometric data and will fall within the scope of the prohibition. So you can see how the facts and the context are really important. And then lastly, what's important to highlight here is that this prohibition exclusively applies in the workplace. The European Commission applies a broad interpretation of workplace in its guidelines and a broad interpretation of employees. So it would apply to all categories of the working force, employees, contractors, trainees, volunteers. It also applies during the recruitment process. Therefore, using webcams or voice recognition systems to infer an employee's emotions, such as anger, would be prohibited. Same thing if you are inferring emotions of a candidate during the recruitment process. And then same thing regarding the education context. This is interpreted very broadly. It applies both to public and private institutions, no limitations regarding the type of age of the pupils or the students, or the specific environment in which they are receiving their education. That said, there are several exceptions. I mentioned some already, just to highlight again that there are exceptions for medical reasons, which is interpreted mainly as a therapeutic use of emotion recognition by authorized medical devices that are used within the European market. And also for safety reasons, this should be understood as safety in relation to the protection of life and health, not of private property or other particular interests. So with that, we move to our final section for today's presentation on how do you assess risk. And just to start off as a general comment, once again, picking up on some of the key notes from the European Commission's guidelines, the European Commission states that the application of Article 5 will require a case-by-case assessment. So what the Commission is saying is that AI risk assessments have to be done on a case-by-case basis. This is similar to what we already know under GDPR with DPIAs, where you need to carry out such assessments on for each processing activity to the extent that there is a high risk element. how do we carry out an AI risk assessment? There is no methodology that is set out in the AI Act. The EC, European Commission, does not give any precise methodology either in its guidelines. But I think going back to what Leonie was saying earlier, there is a lot that we can leverage from our past experience and pre-existing GDPR documentation or documentation in other areas of laws. So here we have put some 4 sort of key steps that are based on good practice, I would say. First, you need to know your AI systems. This is obvious because if you don't know your AI systems, you cannot assess the risk or the potential risk of your systems. Second thing that you need to do, you need to identify your role as either a provider or deployer, because as we saw at the beginning, the actions that are taken on the AI system, whether it's placing them on the market or putting them into service or using them, will determine how your organization qualifies under the AI Act. And then third, as I mentioned already, you need to analyze in detail the purpose, the scope, the objectives, and also the context in which the AI system is either developed or used. Here we see some parallels and similarities with a DPIA, but I would highlight again how important the context in which the AI system is used, how important that is when conducting your AI risk assessment. And then lastly, you will want to document your assessment, because even though the regulators are not yet currently in force, when they are and when they start carrying out their investigations, they could ask you to provide evidence that you have carried out an assessment. And so similar to the GDPR, it's always good practice to document everything that you are assessing and analyzing. Now, within Fieldfisher, we have already developed and started testing with our clients some AI risk assessment matrix documents and tables. We are also developing, well, we have developed a platform, a data compliance manager platform, which is already available. As you can see on the slide, we have roughly 8 modules that enable you to comply with different aspects of GDPR. We are expanding this to the AI Act, and so we are in the process of integrating a specific module on AI risk assessment. The benefit of this type of platform is that you can record, you can save all of your assessments on the platform. This is an ISO 20001 certified platform, and it's also cloud-based, so it's accessible from wherever you might be based on the planet and at all times. It also enables you to get into contact with your Fieldfisher point of contact if, for example, you have carried out your AI risk assessment and then you want to run it through, or you have some specific questions that you might want to raise with your Fieldfisher contact. So these are some of the tools and services that we make available to our clients. Additional information that is available to you, if you go on our Fieldfisher Insights webpage, you can find an article that our speaker Ines Benazouz with one of our colleagues has just written on AI prohibited practices, and this article goes into more detail on some of the topics that we addressed today. You can find more information, more generally speaking, on our website. And then, as mentioned, all of our presentations and trainings and webinars are available on our YouTube channel. And then for those of you who have been following our AI webinar series in 2024, we ran a number of webinars on different topics in relation to AI and the EU AI Act. They are all available on YouTube. You can access them easily if ever you want to go back and listen to any of these webinars. With that, I believe we have 1 minute left. I don't know, Leonie, if we have time for any questions, if there were any questions that were
I don't think we do, Olivia. I think the best thing probably to do is that there's a couple of questions that we follow up when we're sending out the slides, and we can address those questions maybe as part of that, because I don't want to keep people beyond the top of the hour.
Sure. Well, thank you everyone for listening in. Hopefully you found this useful. And yes, as Leonie just mentioned, we will get back to you for those of you who have dropped questions in the question box. Stay tuned. We will be organizing other webinars throughout the year. And thank you, as always, for your fidelity and participation to our webinars. Thank you very much, and have a nice rest of your day.